This episode of Off the Cuff is brought to you by Weaver Simmons, and we're very pleased to bring it to you. I hope you enjoy it.
Welcome to Off the Cuff. I'm Darren Chohan, and this is the second part of our deep dive into family law forms. So today we'll be looking at Form 13 and Form 35.1, and I hope that this is insightful for you. And for those of you who don't know what Form 13 and 35.1 are, they are the financial statement that you have to fill out in a family law proceeding, as well as the 35.1, which is an affidavit for custody, access, decision-making, responsibility, parenting time, and contact. So those forms are integral to proceeding in a family law context. You need to fill those forms out and file them with your application, which is the document that starts the court action against somebody. And so if you find yourself struggling, especially, and I find with a lot of my clients struggle with interpreting and figuring out the financial statement, it's oftentimes a challenging document to fill out. Especially if you don't understand your own finances or you haven't been the one in the relationship that controls the money. We find that a lot too, where one partner in the family law context is the one designated to handle all the bill paying and all the mortgage stuff and everything. So if that's not you, fear not. That's what this episode is about. This is for you, the person that doesn't know how to fill out Form 13, doesn't understand it, doesn't understand financial terms. This is supposed to help you navigate that. And of course, at any step of the process, if you ever need assistance, we discuss limited scope retainers, and that is important because you can get assistance on a lower cost basis from counsel. And if you are somebody who is low income and doesn't necessarily have the means to even pay a lawyer to review your documents, there are services out there like the Family Law Clinic and Legal Aid, Duty Counsel, who can assist you looking at your forms, help you out, navigate that process, and be there with you in court. So again, I'm happy to be here. This is part 2 of our deep dive, and it brings me real happiness to be able to release this content to people, to assist those who are struggling and to provide another arm of access to justice in a world where all we do is see costs rising and the economy failing, especially in today's political and economic climate. So stay tuned. We're going to take a short break and we'll get right into the content you've all been waiting for.
Make sure to like, follow, and subscribe.
Welcome back, and I've loaded up here for those listening the Form 13 financial statement. So it would be helpful if you are just listening to this without the visual. You can open up the form and take a look at it with us. If you are watching the video, well, great. You can just see what we're doing. So here I've created a fake file. You can see my name, and that's my assistant's name. Me as the lawyer, and the respondent's lawyer is just another lawyer in Simmons. So here on the financial statement, this is the Form 13 that we're using for support claims only. And we want to fill out this to the best of our abilities, especially if you're responding to a claim for support, but not necessarily if you're making one. A good rule of thumb, though, however, is any time that there are children and child support requests, you should always just fill out a Form 13, because in the event that you are going to make a claim for daycare costs or braces or Section 7 expenses that are, like tuition, glasses, if you're sharing those costs under what we call the Section 7 expenses, both parties are obligated to file a financial statement, even if only one party is paying child support. So as long as you're filing an application, you should always just file a financial statement. It's best practice to do that. So here you're going to check mark applicant as you're the one filling out the form. And it tells you here, you must complete this form if you're making or responding to a claim for child support or a claim to change support, unless your only claim for support is table amount. But as I said earlier, just fill one out anyways and fill it in, because the lawyer on the other side or the court will end up making you do one, especially if you start to make claims for a contribution towards special or extraordinary expenses for the kids. So here you go down to page 2, you fill in your name, you tell the court where you live. So I type Sudbury. I'm currently employed. And you can check more than one. So if you're employed, but then you're also self-employed by carrying on the business as a law corp 101. And then I'm going to check mark all that applies. So I'm going to attach, my pay stub from Weaver Simmons. And then I'm going to attach a statement of income and expenses from Law Corp 101. Last year, my gross income from all sources. So this is everything you would have earned in the year from employment income. You put in to here because you're telling the court what you earned last year. So this would be the prior tax year. And if we're in tax season now, 2025. And so if you have your T4s, you can actually write in, 100,000, and you can write 2024. So that the court knows and the other person reading this knows that you're actually reporting your 2024 information by adding up all your T4s. Here, this is very important. You're attaching all the required documents. And so you have to read through this. Personal income tax returns, T1 general forms, T4 slips are not needed, but you want your notices of assessment. And it again highlights for you the past 3 taxation years. So you need pay stubs. You need your statement of income. You need your personal income tax returns. You need your corporate tax returns, if you have any, if you are Law Corp 101, and notices of assessment from both personal and corporate. And if you are earning income on reserve, you will fill out this portion. The next section asks you how much money you're receiving per month. So on $100,000, let's just say I'm receiving $83.33 per month. That's my current income, and my self-employment income is about $500 a month from Law Corp, and I'm getting $1,000 a month from a prior support payment. We're getting $500 in child tax benefits. And so then you're going to end up, if you're handwriting this or filling it out, you have to calculate it. We have, for us, of course, we have calculators built in, but you would fill this out and you would calculate your monthly source of income here. Any other benefits you receive. So oftentimes what we'll see is vehicle. And this is work truck, and that could be worth $10,000 a year in value to you as an employee if you have a work truck, for example. And the other common misconception is that child tax benefits are included in child support calculations, but they're not. The only thing we use for child support calculations would be actual employment income or income derived from corporate income or sole proprietorship income, however it's reported on your tax return. We typically look at the line 150, I think it's now 1500 so if it line 15,000 for total sources of income, and that's what we use to calculate child support, generally speaking. Then you're going to work your way down to the expenses, and people get overwhelmed with this, but this is, again, you want to calculate this on a monthly basis. When you're calculating these CPP contributions, EI premiums, income taxes, etc., you can just take that from your pay stub and you look at your 2 pay stubs for the month, take your CPP contributions, add them up for that month, put them in the monthly amount, and do that for the remainder. Your housing, similar, you just put your monthly amounts for all of these items that are applicable to you. If you're wondering why we do a budget, we look at this for people who say they cannot afford to pay child support, or they can't afford to pay spousal support, or somebody who's saying like, I'm way over my head here. I need these child support payments and this person's not paying the child support. It gives us a snapshot of your current expenses and your life to be able to assess the need for those support payments. Then you scroll down into the assets here. This, if you own a home, and then the current value of the home as an approximate value, if you know it or if you don't know it. You can ask a real estate agent or an appraiser to appraise it. But for the purposes of this form, you're just looking for a general amount. So if you believe the house that you own is worth $350,000, you would put that in, and you just keep following. It's cars, boats, vehicles, and again, if you need to add more space, you just make the table bigger, and you can add as much as you need to do there. And so again, same with other possessions of value. And here in this section, we're only looking for major items. So you're going to put, big ticket items. You're not putting small things. So if you have a coin collection that's worth $50,000, then that's important to know. Investments, bank accounts, savings plans. So this is all fairly straightforward stuff. Bank accounts, again, what they're looking for in this form is that you disclose your bank institution and your account number so that it can be verified. And typically later on, you'll end up being asked to provide statements from your bank accounts. And that's fairly normal. And you would do that in the event that there's a discrepancy, an income discrepancy that requires that production of those bank statements. Savings plans, RSPs, pension plan, etc. will go here. And again, because it's a Form 13, it's fairly straightforward. From the perspective of there not being any property questions. It's more just to get a financial picture of you and what you can afford and can't afford and what you have from an asset holding perspective. The next section is also self-explanatory fairly. It's the debts, and you just fill out what the debts are, what's owing, what's being paid, and if you are paying them. And once you get through that section, that's it. That's the end of the financial statement. You have to get it commissioned by somebody. If you are self-represented doing this, filling it out, the courthouse does commission, so you can get a commissioner stamp. The ladies at the registrar's office are also commissioners of oaths, and they can commission these documents when you bring them in to be filed with the court. This is the proposed budget. Typically, this doesn't have to be filled out. If you have additional sources of income, you would fill that out in Schedule A. If you have other income earners in the home, you would fill that out on Schedule B. And then Schedule C, you would fill out if the kids, James Smith, hockey, $5,000 a year, and no tax credits or deductions. So this is just the way that you're telling the court what your children are costing you from an extracurricular standpoint. So once that's done, you will verify it. You'll make sure all your calculations are correct. And then you will get it sworn with the attachments. And then that forms part of what you're going to file with the court. And that's your quick whirlwind tour of the financial statement. Again, it's always beneficial to get legal advice if you're struggling with it. You can ask counsel or duty counsel at the courthouse to go through it with you to make sure you've disclosed everything and that you have all your attachments before you serve these documents on the opposing party. And so with that, we'll take a small break and we'll get back into one of the last most common forms that we see. Welcome back. And before I dive into it, I just wanted to take a moment to reflect on the fact that I am going through these forms fairly quickly. And as I go through them, I realize how overwhelming it can be to somebody who doesn't know really anything about this process. And so I did want to highlight the fact that lawyers, not just myself, but other family law lawyers and other lawyers in different jurisdictions and communities, offer what's called a limited scope retainer. And so you, as a self-represented person filling these forms out, can fill them out to the best of your ability, and then you can pay a lawyer to review them for you. And in that moment, by doing so, you create a solicitor-client relationship. And that lawyer can then also give you strategical advice in your meetings about your file. And so it's more than what I can do today on a podcast and just give information about the forms. But if you were to form that solicitor-client relationship and ask the lawyer for a limited scope retainer, but do a lot of the legwork yourself, so that would mean that you would be scheduling the dates, you would be attending court, you would be attending the conferences, and drafting all the materials. And the only involvement from counsel would be to talk to you privately at their office or wherever and give you advice on your documents and give you advice on your file. So that's one approach to cutting your costs, because we as lawyers recognize now today the climate, and it's expensive, and people are struggling. And so we always want to help. And I would encourage you, if you don't have necessarily the money to retain a lawyer, but you feel confident in your ability to fill out the forms, that you hire or speak to a lawyer to review them for you at a much lesser cost. So that's just my public service announcement for limited scope retainers, because a lot of people don't know that exists. And, our office, we do them for sure. And you can call other family law lawyers and just inquire as to if they'd be willing to take you on a limited scope where you do all of the heavy lifting and they just assist you in the background. That being said, the last form we'll look at for this episode will be 35.1. It's called the Affidavit for Decision-Making Responsibility, Parenting, Time, and Contact. It's another mandatory form that you have to fill out when you're filing your application. And this one, apart from the other ones, is typically one of the relatively more reasonable ones to fill out. As you can see, again, in my test file here, I have a child listed with their birthday, their age, and here is where you would write in paragraph 2 full legal names of parents. So each side would have each parent, and then again names of all the people the child lives with now, and then your relationship. So of course, in my case, be the father. Paragraph 3 is asking for other children that are involved in the case that may not be the biological children. Paragraph 4 is asking if you've been part of any other family law court case and where. Paragraph 5 is asking if you've been involved in civil protection proceedings. 6, if you've been found guilty of any criminal offenses, or 7, if you've been charged. Now, what we typically see here is the court likes you to write in NA in each of these paragraphs, just so that they know they can skip over these paragraphs and just move on. Paragraph 8 is something that we've seen that's on the rise, of course, since COVID, is domestic violence. And so if you are a victim of domestic violence, you or a child, it's important to tell the court about that domestic violence. So you will detail that in your application. But paragraph 8 of this Affidavit 35.1 gives you the opportunity to talk about the domestic violence issues and abuse issues. And domestic violence today is not just physical assault. It's emotional abuse. It's financial abuse. And so if you feel like you've been the victim of any of that, paragraph 8 is where you're going to detail all of those behaviors that you've been exposed to, so that the court knows, because this is a sworn document. So this is just like testifying in court. And so I would encourage you, if that is you and that's your situation, to fill out paragraph 8 so that the court knows about it. And I'll go on a small tangent. This form is very important because it will follow you all the way to trial. And if you just choose not to include the allegations of abuse now, when you get to trial and you serve an updated 35.1 as the rules require you to do, and you put in the details of abuse, the court's going to ask why you didn't do that in the first place. And so you have to be ready to answer that question. But the better practice is that if this is something that has been ongoing for years, leading up to your separation, don't have the fear to include it in the court pleadings, because this is what will follow you all the way to a trial and becomes very important when you're trying to lead evidence about the abuse. And if you've not brought it up all the way up until trial, the court is going to question your motivation for having brought that up so late in the process. Because if you're at a trial, that means you've gone through a case conference, a settlement conference, and a trial management conference, and probably some motions in between and more judicial intervention. And if the court doesn't know about that, that's problematic. And if it's never brought up, that's problematic. And the general rule of thumb is that we don't litigate by surprise anymore. And judges hate surprises. Opposing parties hate surprises. And the goal of family law litigation, especially family law, more so than other contexts, is that the court is tasked with finding what's in the best interest of the children. And if there's been intimate partner violence, and if there's been abuse, and if there's been child abuse, but one party just wants to sweep it under the rug, that really handcuffs a court from making those decisions in the best interest of the children rather than the best interest of the parties. So I just want to say how important paragraph 8 is, and make sure that you strongly consider filling it out if you are a victim of domestic violence, because it becomes very important later on in your court case. Paragraph 9, fairly straightforward, yes or no. With respect to civil protection orders. Paragraph 10, criminal offenses. And that's your opportunity, if the party has been arrested for domestic violence, to detail those charges there. Paragraph 11, that is to fill out a history of where the child has lived. So typically we'll see something like Darren Chohan, Catherine Webb, birth to separation. You'll add a line, and then this will be that the child has lived with Catherine from separation to present date. And so this is your ability to update the court the residence of the children. And this, again, if you have multiple children, you have to fill out each line for each child here. Paragraph 12, my plan for care. This is very important that a lot of people forget to fill out. You need a plan. The whole point of the 35.1 is to tell the court what your plan is. You can't ask for joint decision-making or residence of the children, sole decision-making, any of that, if you don't tell the court what your plan is. So, here I plan on living at 123 Law Way in Sudbury. And then here, this is if you've now got a new partner. So if I have living with me now, I have Jane Jones. She was born 1/1/1990. Partner, no for Children's Aid Society and no criminal offenses. But then also it's important if Jane has a child. So if Jane has a child named Johnny Jones, born 1/1/2007 or 8. And again, and so on and on as you fill it out for all the people that are living with you at 123 Law Way in this scenario, which would be me. Here again, this should match at 12C. Decisions for the children will be made by. So if you've asked for joint decision making in your application, then you're going to say jointly by me and Catherine Webb. And we see this filled out incorrectly a lot too for paragraph 12D. What do you do? Okay, well, I work full time. And then a lot of people forget to say where. So here, Simmons. If you anticipate any changes, you can put that there. The children will be going to Our Lady of Church Daycare and will be also cared for by my parents, Sandra and Keith Johan, when the daycare is closed. So again, this is just details about who's going to be caring for the child, who's in the child's life. And this is all very important because this is what informs the court of all of the caregivers that are going to be involved in the child's life. My plan for the other parent's time with the child. And again, this has to be consistent with what you've requested in your application. So in this case, we are going to say every second weekend with the respondent. And then contact with others. And this is what it's asking you. I will continue to facilitate parenting time with the respondent and provide the child visitation with the maternal grandparents and extended. It's just telling the court that if the child is residing with you full-time, are you going to facilitate relationships with other family members, friends, etc. And this is your opportunity to tell the court what you're going to do with the child. And here, of course, if you have a child with special needs, you will have to fill this part out. If not, you say the child does not have any special needs. And then I will have the support from the following relatives. So again, this should be consistent with above. Sandra and Keith Chohan, Bob and Dylan Sanders, sister, etc. And so you detail all of the people that will be involved in the child's life, and you go down, click no on paragraph 14 if there's no child protection agencies involved, and you get to the bottom and you swear the document. And that's it for the Form 35.1. So I'm taking you through the majority of the forms that you'll see in the family law context. And so next time when I go through the forms, I'll be taking you through the divorce claims and the Superior Court of Justice stuff. So this was a fly through of the Ontario Court of Justice forms as a self-represented individual. To note, I did not go through what's called a 35.1A, and that's if you've been involved with the Children's Aid Society in any capacity and they have opened a file, you will need to file what's called a 35.1A with your documents. And so just to be aware of that, that's something that you will need to do. And apart from that, those steps, once you fill out all those forms, you take them to the courthouse to get issued. And once they're issued, then they can be served on the other party. For service of the other party, we always recommend that you do not do that yourself in case things escalate, especially if you've been a victim of domestic violence. Do not attend the other person's residence and serve these court documents yourself once they're issued. There are individuals that you can hire in every region to do process serving, and that's what it's called. So you just type in your city, process serving service, and figure out who can do it for you. There's a national company called Canadian Process Serving. They have people everywhere locally in different cities to do that for you. If you want to save money and not pay to have it served, we recommend you use a relative or a friend, a mutual friend perhaps, to just hand over the documents. Once that's done, you'll need to have that person swear what's called an affidavit of service, stating the date and time that the party was served. So I hope you have enjoyed this unique episode. I'm, of course, doing it myself. I don't have a co-host any longer. I'll be trying to come up with innovative ways to engage the audience and release more episodes and do more things. Like I said, the next part of this series will be talking about Superior Court and divorce, so stay tuned for that. And then we have some episodes planned on immigration law, which is booming. So I'm going to be interviewing some of our immigration lawyers at the office, and they're going to be giving us some information about applications and immigration. So, I thank you for sticking with me if you've made it this far through the episode. And I hope to do more content in the future. And as we've got some planned out, and hopefully I can get those released. Not so big gaps in between. And keep me in the loop. Put in the comments. Send us an email. Shoot us a message. Do whatever you need to do to get a hold of us. You can even pick up the phone and call and say, hey, I watched your podcast, or I listened to this. I just want some clarification, or I think you guys should do this, and different ideas. We're always looking for feedback in the community. Our Instagram is still there, Off the Cuff by Weaver Simmons. Take a look for that. We often post some giveaways for Wolves games, etc. on our Instagram page. And it's great to be back. I thank you for tuning in. And I'll catch you next time. My name's Darren Chohan. This was Off the Cuff. Have a good night.